LSO, go ahead and take the roll.
Representative Chadwick.
Here.
Representative Haroldson.
Here.
Representative Harshman.
Excused.
Representative Knapp.
Here.
Representative Newsom.
Excused.
Representative Ottman.
Here.
Representative Wiley.
Here.
Representative Yin.
Here.
Chairman Olson.
Here. All right, committee, we are going to work through two Senate files today, believe it or not. I know it's a change in pace for everyone. See if we can manage it. We have Senate File 22, and then we'll have Senate File 79. Senate File 22 is the Public Service Commission Electricity Reliability. Should all have in your folder a little blue bill. It looks like the Senate did some work on this bill. This is reliability of new generation. Public Service Commission shall not allow the inclusion of any facility generating power that is intermittent in availability if it is likely the operation of this facility will result in failure to comply with reliability standards. And there's a penalty on page 3. Civil penalty not to exceed $100,000 for each day that the violation persists, with a maximum civil penalty of $1 million. And it looks like the Senate amendment took place on page 2. I think. Yeah. Page 2, lines 16 through 18. They changed the language. I'm not exactly sure what they were doing. I guess we'll figure that out, but I don't really see, I see the change, I just don't understand substantively what they're actually doing, so we'll see. All right, committee, anything to add to the bill before we begin public testimony? This was a bill, as you all recall, from the interim. Okay, let's go to our Public Service Commission. Welcome.
Thank you, Chairman. I'm Chris Petrie. I'm Deputy Chairman of the Wyoming Public Service Commission. Commissioner Robinson and Chief Counsel John Berbers are with me today. We believe that we understand this bill in its engrossed form. I don't believe that we have any reason to be concerned about it. We understand it, and as I believe we told the Senate committee, there are a couple of applications in front of the commission now to establish the reliability standards that are mentioned on page 2, where the date is set for December 15th, 2024. It's in line 14. And we have discussed that we do believe that we'll have those standards established based on the fact that we've got those applications in front of us now. So we think that deadline is fine, and we understand the rest of the bill.
Commissioner Petrie, I would assume that adequacy and reliability is already part of the analysis that the Public Service Commission goes through. So what, from your perspective, what does this bill do above and beyond what the Public Service Commission already does?
Mr. Chairman, certainly integral to everything that we do at the Public Service Commission with the utilities, safe, adequate, and reliable service at just and reasonable rates. You've heard us say it a lot of times. And adequate and reliable is certainly part of that. That doesn't necessarily mean, though, that we have a specific concrete standard established for each utility. And so each utility operates in different conditions, they have different types of customers, they have different densities of customers and so on. And so in House Bill 200, this was a part of that new statute where our job was to establish a standard so that we would have a means of comparing ongoing performance with what we had at a point in time. And so the point in time is now going to be sometime no later than December 15th, 2024. We have now very good reliability and adequacy. I think we don't have a current problem. So the idea here is that we'll establish this standard based on the applications of the utilities and our own analysis and any participation by any intervening parties that want to contribute to that process. And then we will be in a position to monitor that for any deterioration of reliability and adequacy.
Okay, and my second question is the Senate amendment. Do you know exactly what the Senate amendment is doing that is different from the committee version, the interim version? Because I think I see where the amendment was made on page 2 to that subsection A.
Page 2A.
It looks like they struck out related on, which used to be on line 16.
And what's this?
And then the rest of it remains the same, and they just changed the sentence up a little bit. I'm just not sure what, maybe you were there when the Senate discussed this amendment. I could always follow up with them if you don't know, but I just thought maybe you would know what they were doing.
Chairman, I think that the deletion of related and insertion of insurer was really just a wordsmithing maneuver because the purpose here is to ensure that we're getting what we want in terms of reliability and adequacy. And I think that related just did not convey the correct meaning.
Okay, and it looks like the other change actually is a substantive significant change. Representative Wiley could appreciate this. On page 3, the change went from a shall to a may. The commission may disallow the inclusion of some or all of the investment associated with non-dispatchable resources, et cetera. So that's the engrossed version. And the committee bill said that the commission shall not allow the inclusion of any facility generating power that is intermittent. It looks like they reworded the rest of the sentence as well. Do you recall a discussion of that subsection?
Mr. Chairman, I don't recall in detail the discussion.
Okay.
Commissioner?
Commissioner Robinson?
Mr. Chairman, my recollection is that was to preserve the commission's discretion in reviewing the costs associated, and that we could then use our expertise to determine what is or what is not recoverable. It's under these kind of situations, it wouldn't always be clear. And so I think the may was just to recognize that we have some discretion in making that determination.
Okay, yeah, I would agree that's what it does. Which I would ask you how you really feel about it, but of course you would prefer to have the discretion, right? I get that. Committee, Representative Yin.
Thank you, Mr. Chairman. Commissioner Petrie and Robinson, thank you for being here. Do you think, or would it be in your opinion, so there's pros and cons and costs and benefits associated with prioritizing anything over anything else, right? So we're prioritizing dispatchability, and it may include a higher cost to prioritize dispatchability. If we prioritize dispatchability and another state decides it doesn't necessarily want to prioritize dispatchability and may not even want to buy the power from us, would it end up increasing the rates that folks in Wyoming have to pay?
Mr. Petrie? Commissioner Petrie, sorry.
Mr. Chairman, Representative Yin, I don't think that in this context where we're talking about the reliability component of service, that it's necessarily calling a heavy favorite for dispatchable. This is maybe not a terribly powerful distinction, but I understood these provisions as trying to guard against utility inclusion of excessive intermittent resources to the point where it interferes with their historic reliability standards that they have managed to meet. And so it's more cautionary than favoring to me. It's to discourage going too far to the point where you have a reliability problem.
Any follow-up, Representative Yin? You good? Any other questions for the commission committee? Just so the record's clear, it looks like the language was also adjusted below that in Romanet 6 to make it clear that we're talking about a public utility failing to meet the requirements of the subsection being subject to a penalty. So I understand that one. Committee, any other questions for the commission? Anything else from the commission?
No, thank you, Mr. Chairman.
All right, thank you for being here. Any other agencies? I don't think we have. I haven't seen our Office of Consumer Advocate. But I guess I don't have anything to say. Public comment. Mr. Lindholm.
Thank you, Mr. Chairman, members of the committee. Senate File 22, first of all, my name's Tyler Lindholm. I'm the State Director for Americans for Prosperity here in the state of Wyoming, and we're on and in favor of this legislation. The language follows on reliability, which is aligned with our goals here in the state of Wyoming as far as ensuring that we don't find ourselves in a situation much like Texas or California, where they've gone so far in some of their standards that they've adopted. It's created situations of brownouts and blackouts. It's called the duck curve effect. If you really want to get bored this afternoon, it's fascinating reading. It was invented in 2012 in California with some of their reliability issues. But Mr. Chairman, members of the committee,
Got all the time in the world. We could just have you summarize that for us.
Mr. Chairman, I could draw it out. It's actually pretty fast. We better not, though. On the third page, Mr. Chairman and members of the committee, lines 1 through 9, the language indicates that the Utility Commission shall not allow a utility to earn a rate of return, which can be substantial in some instances if the new or modified generation facility at issue produces intermittent power, if it is likely that the operation of that generation facility will result in failure to comply with reliability standards. And then lines 11 through 17 on page 3 outline substantial penalties for those violations, and you had gone over those, Mr. Chairman. If this or similar language is enacted, the commission is directed to establish those baseline standards, Mr. Chairman, second page lines 14 through 18, for reliability related to dispatchable power in the state. This will occur through a rulemaking process, primarily, Mr. Chairman and members of the committee. It will be necessary to pay close attention, if this were to pass in law, pay close attention to those standards, so that they're set through that process if it occurs, as those standards will be the foundation upon which the statute will be enforced. Some utilities, Mr. Chairman, members of the committee, some utilities may not like this language because it will hold them accountable for reliability. I suspect that those same utilities may also attempt to soften that rulemaking process. And so, Mr. Chairman, members of the committee, while we're certainly on in favor of this legislation, I hope that this committee will pay close attention to the rulemaking process as it's going through.
Questions for Mr. Lindholm? All right.
Thank you, Mr. Chairman.
Lindholm. Commissioner Petrie, this bill doesn't have specific language for rulemaking authority, and I'm assuming that it's just not necessary because you can already engage in the rulemaking process. Is that?
Mr. Chairman, you're correct. There is already rulemaking authority granted to the commission, including in House Bill 200, and that rulemaking processes. We've engaged in that, and to the extent we need to revise rules related to this, we already have the authority to do that.
Perfect. Okay, I just wanted to double check on that. Public comment. Mr. Bush. Welcome.
Thank you, Mr. Chairman. One of my favorite committees to appear before. David Bush, Black Hills Energy. Staff right now is passing out an amendment. I can talk about that here in a minute if the chairman and the committee is interested in moving this bill forward. We would ask that you consider this amendment. Generally, well, let me back up. One of the questions you had was the change that the Senate made on page 2.
Yes.
And part of that change was based on another piece of legislation that's moving through that just actually came over to the House, I believe yesterday, Senate File 42, which is low carbon energy standards. It's amendments to 2020's House Bill 200 that we worked with the Minerals Committee throughout the summer. There was language in Senate File 42 that kind of tripped over this language. So the Senate committee sort of adopted that 42 language. I think they liked it better, if I remember right. So
Got it. Yep,
that was that part.
That's really helpful.
The other, I think the characterization from the commissioner on the other changes is accurate, where the Senate committee just had their own thoughts on some of those other changes. But that specific change on 2 was because of that other legislation and just making sure they didn't come in conflict. I think, Mr. Chairman, as I said, the bill in general does a lot of what the commission already has the authority to do. It also brings in, there are federal agencies that cover reliability as well, FERC and NERC, that also have the ability to fine utilities for issues that arise from reliability and things like that. So I understand the impetus behind the bill and the reasoning by the legislature. So we are where we are on that. But if it is the committee's desire to move the bill forward, and I apologize, I just noticed that the amended language that I'm proposing on page 3, this was accidentally put on the original bill text and not the engrossed copy. So that's my fault there. I apologize for that. The language is basically, the amended language is the same. It's not changing any of the engrossed language. It's adding new language to the engrossed copy. The purpose of these two sections, and I have shared this with the commission as well and others, we have a unique contract tariff that we use here in Cheyenne with one of our large data centers. It's the large power service contract, I think is what it's called. It's a unique tariff that we use just for them. It's basically, it protects our other customers from any sort of costs that may be associated with that large customer. It's a unique way to protect them from the high power costs that come with serving that other customer. So what this amendment basically does is ensure that we can continue to work with that customer to serve their needs while also continuing to protect the other ratepayers in Cheyenne and ensure that they're not impacted by that. So it's just sort of in our minds, I guess it's sort of like the rest of the bill, ensuring that what's going on now can continue. And we're just putting it into the statute. So that's my basic testimony. I don't know if you have any other questions on our operations here in Cheyenne or the bill or anything like that, so.
Just so I'm clear, without this amendment, what is Black Hills' position on the bill?
We are, I guess I would say we're not in favor of adding more regulatory burden, but again, understanding where we are in the world and where the will of the legislature was this summer, we're okay with it.
Does the amendment move you from not wanting regulatory burden to wanting regulatory burden?
Mr. Chairman, it does not.
Oh, okay.
It does not. If the committee decided that this bill wasn't necessary, I wouldn't fight you on that, but I'm a realist.
Committee, questions for Black Hills? Representative Haroldson.
Thank you, Mr. Chairman. Mr. Bush, thank you for coming out. I guess a question with this, obviously, thanks for being honest about the bill. But if you don't get this, does this have large impact to your operation? If you don't get this amendment that addresses that carve out that you guys have for that large ratepayer?
Mr. Bush?
Mr. Chairman, Representative, that's a good question. I think we have some attorneys that would probably say that puts it at risk, and it gives them a little bit of heartburn, as can happen with attorneys. No offense to any of the attorneys in the room. But I think it would make us more comfortable with the bill passing if that language was in there, just knowing that we were going to be able to continue to serve that load the way we have been. And it's been a great opportunity for Cheyenne, the growth that we've seen, so.
Okay, additional questions for Mr. Bush? Representative Ottman.
Thank you, Mr. Chairman. Mr. Bush, if the amendment does pass, or if it doesn't, and the bill, does it change your purchase power with purchasing your electric and the rates that you can get?
Mr. Chairman, Representative Ottman, it doesn't change, are you asking if it changes the pricing for us, or? I don't think it would. The bill basically, again, goes back to what we already do with our process with the commission in reviewing our needs for power and reliability standards and things that are already in place. It merely codifies that. So it just, again, puts into the green books what they already, I would argue, have the authority and do on a regular basis. I don't think our reliability has been an issue, but again, understanding the questions surrounding this summer and fall, I get it.
Now, hold on, Mr. Bush. If this bill codifies what is already the practice of both the PSC and what is already your practice, then why aren't you more neutral on the bill or favorable to it?
That is a great question, Mr. Chairman.
Okay. I guess we'll just leave it as it, at that. All right. We just want to get you to the point of neutrality. We'll get you before the end of the session, maybe. Other questions for Mr. Bush?
Yeah, Mr. Chairman,
Oh, yes, Representative Wiley.
thank you. Mr. Bush, did you bring this amendment to our counterparts earlier in the process?
Mr. Bush.
Mr. Chairman, Representative Wiley, we did not. It moved through the process a little faster than we had anticipated, so we did not have time to examine that. We've spent a considerable amount of time on some of the other legislation that has come through and amending that, and just didn't get this one in time, so.
Any other questions, committee? All right. Thank you, Mr. Bush.
Thank you, committee.
Mr. Kaysen. Welcome.
Thank you, Mr. Chairman, members of the committee. Rick Kaysen, representing Rocky Mountain Power. Please bear with me while I plow a little bit of ground that's already been plowed, but I think some repetition is okay. My understanding, my belief is that the Public Service Commission has some authority to take a look into the reliability, especially if there are incidents or occurrences where reliability is really questionable. Okay, there's a trend of non-reliable service. So I think the Public Service Commission already has some existing authority there. When we think about what was stated earlier about the utilities' responsibility for reliability of service as well. And I'm going to comment on that just in a little while as well. To the best of my knowledge, the commission has not had to conduct any investigations for I don't know how long with regards to the standards or to the existence of reliability. So that's something to keep in mind. As was just mentioned shortly ago, the Federal Energy Regulatory Commission, as well as the North American Electric Reliability Council, otherwise known as NERC, also have rules and regulations in place and have had these rules and regulations in place with regards to reliability for a good number of years. And so electric generators are already being monitored, if I may, looked at the federal level. Again, to the best of my knowledge, there have not been any investigations in the state of Wyoming by either of these two federal agencies. The Public Service Commission identified to your question, Mr. Chairman, about reliability and everything else with the, the standard response of safe, reliable, and reasonably powered energy, that type of thing. I think that's very, very important to keep in mind, because that relates back to what we call, and you've heard this before, the regulatory compact, where the electric utility in this case has the right and the obligation to serve those customers in a designated area, and at the same time has that equal obligation to deliver that safe, reliable, reasonably powered energy. So again, that compact's been in place for well over 100 years, and I think it's worked pretty well in the state of Wyoming as well as across the country. A couple other comments, Mr. Chairman, if I may. There was a question earlier about the amendments that were made coming out of the Senate. Page 2, line 14 on with what was the intent of that? Why did they put that in? And I would agree that I was in those discussions. It was the intent for more clarity as far as what the bill was trying to convey in the printed language as well. And then there was also the question, about page 3, line 4, and that was the word shall to may. And we absolutely support the word may. versus a mandated shall. And the reason for that, it does provide the commission some flexibility in their analyses as far as what could take place or what might take place, as well as having the open discussions and trying to explain, a utility may be able to explain what has taken place in an incident or an occurrence. So we like that word may, needless to say. With that, Mr. Chairman, I'll try to answer questions that any of your members may have.
Okay, same question I asked Black Hills, specifically, what is Rocky Mountain Power's position on the bill? Specifically, what is Rocky Mountain's?
I'm sorry, I missed that.
On the bill.
Again, since we are already operating under the rules and regulations of the Federal Energy Regulatory Commission, the North American Electric Reliability Council, we're okay with the bill because, again, that's how we operate. The one thing that I would ask for consideration as we get into the rulemaking process to set these standards is some type of consistency looking at federal, so there's some efficiency there. We're not dealing with two different sets of standards.
Does the large scale tariff apply at all to Rocky Mountain Power? Is that?
Mr. Chairman, at this point in time, it would not, but we have no arguments with that amendment because there is the possibility of creating a similar tariff that's already in existence with Black Hills Energy.
Okay. Committee questions for Rocky Mountain Power? All right, thank you, Mr. Kaysen.
Hello, Mr. Chairman, members of the committee, Sean Taylor, Executive Director of the Wyoming Rural Electric Association. I know you love neutral testimony, and plus I just wanted to make Mr. Moser wait a little bit longer before he got up here. But from the cost perspective, we are neutral because it doesn't apply to us right now, and we're happy with that. It's focused on generation, and I just wanted to make it clear until such time that either our G&Ts start building something other than coal in Wyoming, or if our distribution systems are able to build their own generation, which currently, because of contract reasons, they can't. We're basically exempt from it, so that's why we have a neutral stance. We do agree that the Public Service Commission can kind of already do this, but nonetheless, no heartburn if it passes.
Okay, that's good to hear. Appreciate your neutral stance on the bill.
You bet.
Additional public testimony. Welcome.
Thank you, Chairman Olson and members of the committee. My name is Claire Duder, and I'm with Powder River Basin Resource Council. We urge you to vote no on this bill. We're concerned that it duplicates requirements that are already set for the Public Service Commission as well as utilities. And we're concerned that this discourages renewable energy resources, which we believe is not the message that Wyoming should be sending. We agree that there must be electricity reliability. It's needed for daily life. We just don't agree that this is the vehicle to achieve that goal. And we are concerned about the rulemaking. Based on the language of the bill now, there would be extensive rulemaking that would be required. Questions like, what does it mean for a resource to not operate as projected or materially contribute to failure to comply with reliability standards? And extensive rulemaking means adding more work to an overly burdened Public Service Commission. Utilities will also participate, which means ratepayer dollars will be spent. And getting rid of renewables won't fix reliability issues. In fact, we are particularly concerned with reliability issues stemming from extreme weather events, which we believe will only become more frequent and intense with climate change. So for these reasons, we urge you to vote no on this bill. Thank you.
So if I understand your testimony right, you would agree that this bill specifically targets Wyoming alternative forms of energy like wind and solar.
Yes.
But you would also agree that those are non-reliable at times in terms of the load?
Chairman Olson, it is true that renewable energy is intermittent resources. We wouldn't necessarily say that they're inherently unreliable. We believe that the standards in place already are adequate for utilities to meet those reliability requirements with a mixture of renewables and what's already in their load.
So if they can meet reliability standards, then help me understand the negativity of the bill then, how it would impact them.
We're mostly concerned that it's just already covered. So it's just an unnecessary bill that'll result in more rulemaking.
Okay, so it's not, the Public Service Commission already has the authority to do this. They already consider reliability in their analysis, and the bill just basically codifies that.
Chairman Olson, yeah, we believe that it's just duplicative and not necessary.
Okay. Questions, committee? All right, thank you.
Thank you.
Additional public testimony? Mr. Acey, are you gonna weigh in on this one at all? You're pretty neutral. I could have predicted that. Mr. Bush, you gonna take another bite at the apple?
Yes, this is still my favorite committee, Mr. Chairman. Actually, sir, the Public Service Commission pointed out there is a typo in the amendment that I proposed
Okay,
under the G. 1, 2, 3, 4, fifth sentence down. It says, nothing in this chapter shall prevent an electric utility from also participating. There should be an in regional reliability planning or compliance programs. I'm sure you all would have caught that, but just pointing that out for
great,
good measure.
got it.
Thank you, sir.
Thank you. Additional public testimony? Do we have online testimony? I don't think we've used the online function yet, and we're almost done with session. It's a good thing. People who want to testify show up, I guess. All right, with that, I will close public comment. Committee, what is your pleasure? It's been moved by Representative Haraldson, and was that Representative Ottman? Second? Okay. Do we have any amendments to page 1 of this bill? Amendments to page 2? Amendments on page 3? Yes? Do you want to make that amendment, Representative Ottman? Can you speak into your mic, please?
Thank you, Mr. Chairman. I would move the amendment for page 3 that was presented by Black Hills Energy.
The subsections F and G?
F and G, yes,
Okay.
line 16 on page 3.
All right, is there a second? Representative Yin, second for purposes of discussion. Committee, any discussion on this amendment? There's hesitation to second it, so hopefully there's a little bit of reasoning behind that. Go ahead, Representative Knapp.
Mr. Chairman, yeah, I would resist the amendment only because I think it includes both existing contracts and what could be future contracts, and that kind of negates the intent of the bill.
Additional discussion? Representative Wiley?
Mr. Chairman, thank you. I would also resist the amendment. I think they can already do what they're proposing. If there's a problem, they can come back to this committee.
Representative Yin?
Mr. Chairman, thank you. You know, I think when I think of all of the bills that we have before us in corporations, especially in the electricity markets, is are we making sure that we improve the status of Wyoming, protect our legacy industries, but are we also making sure we're not causing harm by doing it at the same time? I think this is just something to help mitigate the chance that we could cause harm. So I'll vote in favor of it.
Any additional discussion, committee? Representative Haraldson?
Thank you, Mr. Chairman. in the last couple of years, we've been seeing more and more of this where industries are dictating policies when it comes to electricity. And they're stating, well, we won't use electricity unless it's it's generated in a certain way, or it's comes from a certain source. And this is becoming pretty rampant around the nation. And frankly, I struggle with it because what it's doing is it's driving a narrative. And I think this continues to drive that narrative. So on and against the amendments.
Any other discussion, committee? All right, since you're ready to vote, all those in favor of the amendment signify by saying aye.
Aye.
Any opposed?
No.
Okay, I believe that amendment has failed. Any other amendments to page 3? Page 4? That's the bill. Any discussion on this bill? No. LSO, will you do a roll call vote on Senate File 22?
Okay, Representative Chadwick. Aye. Representative Haroldson.
Aye.
Representative Harshman.
Aye.
Representative Knapp.
Aye.
Representative Newsom.
Aye.
Representative Ottman.
Aye.
Representative Wiley.
Aye.
Representative Yin.
No.
Chairman Olson.
Aye.
So that's 8 ayes and 1 no. Do pass.
All right. Thank you, Public Service Commission, again for joining us, and thank you, Energy Industry, for joining us. You can always stick around for the next one, too. But because it involves beer, I'm doubtful you're gonna be neutral on it. Senator Barlow, welcome to House Corporations.
Good morning, Mr. Chairman. Afternoon, Mr. Chairman, members of the committee. Great to see you.
Go ahead, Walt.
You'd
Go
like
ahead
me to
and,
proceed?
yeah,
Okay, thank you, Mr.
at your
Chairman.
pleasure, introduce us to Senate File 79 and walk us through the bill.
Thank you, Mr. Chairman. So maybe just a little bit of background. This bill, this concept in this bill was brought to the Senate Corporations Committee last legislature. And the same people who I think all the same folks who were co-sponsors on this bill were co-sponsors in that last one. And this was brought to us by our craft brewing industry and businesses in Wyoming about a challenge they have with our current laws regarding malt beverage. And so this bill, so when they brought this bill to the committee, it happened to be at that time, Senator Nethercott was the prime sponsor. She brought it forth and said, look, the parties want to work this out in the interim. The interested parties want to work this out. The brewers and the distributors want to work this out. So, Mr. Chairman, this is the result of that work. This is their coming together over the interim and bringing us this product. And as you will see, it's still a white piece of paper. That doesn't mean you can't improve it, but it's still white because as we worked it and went through the process, because it was something that they had worked out, we were trying to be respectful of that. So that's the first thing. This is something that the interested parties have worked on, and so that's one first thing. The second thing is, as you know, because Wyoming has a large role in how alcoholic beverages are regulated in the state, i.e. the liquor. We have a Department of Revenue who deals with liquor and wine, and then we have a little different format for malt beverages. You really, to make any changes, you have to come to the legislature because we have that control. So what this bill does, Mr. Chairman, and there are certainly experts in the rooms, and I don't know if we're going to sing Kumbaya like we did on the Senate side, but there is a broad agreement about where this bill goes. This bill gives an opportunity for a microbrewer, and I think if I can just walk you through the bill quickly, Mr. Chairman, if that's appropriate for the committee.
Please.
Thank you, Mr. Chairman. So this new section of law, and you can see we're creating something new with this first section of the bill, only applies to those franchisors or microbrewers that are producing 25,000 barrels or less. So this is those folks, those community businesses throughout the state that fit into that microbrewery or craft brewing licensure. So as you go through this, what you'll see is, and so currently in state law, they have to have distribution. Certainly they can dispense out of their own facility, but if they want to have a broader distribution, they have to go through someone else. And those distributors, the way current law is, can maybe come up with a franchisee agreement, but then there's no way to kind of reset the button for these brewers. They're captive to that. And what this allows is them to come out of that arrangement with a no fault, or I'm not getting the right word, a 45-day notice. And then if they exercise that, the rest of the bill talks about how they actually unwind that agreement, how they unwind it. Everybody gets paid for their value of their products, and there's a consideration of, all the different things that would have gone on in that agreement. So a lot of this, and if they can't come to an agreement, or there isn't what they think is a reasonable settlement, then there's the second, later in the bill, when you get to page 4 and 5, we talk about arbitration. There's a way through a national organization to have an arbitration and to work these things out. So really, Mr. Chairman, what this is probably, as I said it on the floor, and there's some in the room who may have heard it, like, this is the most patriotic beer freedom bill you're going to see. This is actually free enterprise being able to, do the things that they want to do to grow their businesses. Now, I will note, Mr. Chairman, there is not a repeal of the beer tax in this bill. So we're not maybe completely.
We can make it blue.
But that's the only thing that's missing in this, at least on behalf of our microbrews. Mr. Chairman, there are experts that understand this industry and that understand the discussion that took place during the interim. Like I said, their work was before you today, and I'd certainly suggest they can provide you with more details if there's any interest in that. So with that, Mr. Chairman, I'd be glad to stand for questions. And I did not walk through the bill in its entirety, line by line, because it basically has three things: who it's eligible for, what they can do, and then if they can't come to an agreement, how you arbitrate that. That's the bill, Mr. Chairman.
Senator Barlow, I got to the point of when they want out of the agreement, they can basically just pay the fair market value to the franchisor of the and they're paying a fair market value of the agreement. What else do they have to do? They just buy out the contract, basically. What else do they have to do, or is that it?
Mr. Chairman, there is nothing further
That's it,
than that.
okay.
Notify, 45 days in writing, and then make a payment or whatever consideration they feel. And if there's a disagreement about what that consideration, then you'd go to arbitration, Mr. Chairman.
And I assume the reason why we need this statute is because those franchise agreements obviously do not include a buyout clause. They're one-sided on that.
That is accurate. Thank you, Mr. Chairman.
Okay, I think I'm there. Any other questions for Senator Barlow? Representative Vien?
Mr. Chairman, thank you. Senator Barlow, I did have one constituent reach out. I had several constituents reach out to me in favor, but I did have one specific constituent reach out to me in opposition. I believe he did testify on the Senate side, but I unfortunately didn't watch the testimony. Do you know what his concern was?
Senator Barlow?
Thank you, Mr. Chairman, and to Representative Yen. Certainly, the franchisee was, this relationship was when there was very large breweries and very small distributors. Now we have the inverse of that. Now we have small producers, if you will, for lack of a better term, breweries, and very large distributors. The uniqueness of the gentleman may be here, and if he is, I don't know. Is it somebody waving over there in the back behind me, Mr. Chairman? Okay, no one's waving, okay. But I don't want to speak for him, but I would just respectfully suggest that he is not a large distributor, he is a niche distributor that may find advantage in having this type, maintaining this type of a closed relationship where you sign with me and you can't leave me. So it's kind of an interesting paradigm, and we were one way, and now we're the other way, and yet there's still going to be some natural tension. And I think that the committee heard the testimony. I think they certainly understood it, but I don't know how you can have it both ways. Then you'd have to have a level of distributorship, right? You'd have to, because right now we're talking about microbreweries, we're not talking about large breweries, which I don't know that we have any in the state of Wyoming. But then you'd have to have a different level between distributorships, and I don't know that that makes any sense in the context of this bill. But that was a little bit of a niche type distributor that said, well, I really do need this advantage. And I think we're trying to actually take regulation out of this and let people have a fair market access, whether they wanted a smaller distributor or a large one. Thank you, Mr. Chairman. Thank you, Representative Yen.
Other questions for Senator Barlow? All right, thank you, Senator. Agencies, any agencies first? And then then I'll take general public testimony.
Thank you, Mr. Chairman. Tom Montoya, Wyoming Department of Revenue Liquor Division. I think Senator Barlow said it best. We have very little to do with beer. We distribute spirits and wines. But we did look at this bill, and I actually had the Attorney General's office look at this bill as well. We just want to make sure there's no conflict with any state statutes. And, you know, of course, the microbrewers in the state of Wyoming all have to be federally licensed as well, and they have to follow some federal statutes. And we saw zero conflict with it. So there's no problems as far as that concerned. There's no fiscal impact to the agency.
Okay, I was just checking something. I had an agency impact statement in my folder, but it's not for you. So I just wanted to double check that. All right, we appreciate that. Any questions for the liquor division? All right, thank you. All right. Is that right? Okay, get the full picture.
Thank you, Mr. Chairman. Michelle Forrester with the Wyoming Craft Brewers Guild. We represent all the craft breweries in the state of Wyoming, and we, of course, are very much in favor of this bill. There's little more I can say than what Senator Barlow has already explained about what this bill does and why it's needed. I will just reiterate that the bill before you represents a very long amount of work between the brewers and the wholesalers in the state. We worked really hard to come to a mutual agreement and to ensure that the solution was good for both parties. We need each other in our business. We need to get along, and we need to make sure we're supporting each other's success. And this bill absolutely does do that. It's good for our members. It's good for small business, small manufacturing, and it supports a healthy marketplace for these very, very small producers. So the Wyoming Craft Brewers Guild and its members stand in full support of the legislation exactly as it is written, because every word has been negotiated carefully between the two parties. Thank you, Mr. Chairman. I'll stand for any questions.
Any questions, committee? All right, thanks.
Mr. Chairman.
Oh, yes, Representative Harshman.
Senate must have listened. There were no amendments.
Agreed.
Wow. First bill ever, I think. Thank you.
Mr. Agopian.
Mr. Chairman, Nick Agopian, I represent the Wyoming Beer Distributors Association, here today in support of Senate File 79. We did work hand in hand to come up with the language in front of you, and we believe that this accurately reflects the positive relationship we have as distributors with craft brewers. It reflects what in practice has been occurring, and the change in the statute really reflects and it creates this new right to terminate without cause. The statute today clearly spells out the process for terminating a franchise agreement that's indefinite, but that is a burdensome process for a small brewer. And so we agree that that is a burdensome process. And in looking back, this acknowledges kind of what's going on in practice. It allows for an agreement to occur. If not, then the craft brewer would make a estimated fair market value payment and transfer the burden onto the distributor to determine if that fair market value payment is sufficient. If not, we would go to arbitration. If the arbiter finds that it's a narrow gap between what was paid and what was owed, we would make the party making underpayment would make the other party whole. And then you would split the arbitration costs. If it was found to be in bad faith, we don't expect that situation to occur, that it would then, the arbitrator could then require the craft brewer to pay more of the arbitration fee. So we just don't believe that that's likely to occur. At the end of the day, for us, this bill represents the retention of the three-tier system here in Wyoming, keeps everybody regulated underneath the Malt Beverage Franchise Act, does not create a new burden for the state, and ultimately allows us to continue to help support craft brewers grow. And one good example is the limit is nearly twice as high as a current craft brewer. So this envisions supporting craft brewers grow their barrelage number.
Questions for Mr. Agopian? All right, thanks.
Mr. Chairman,
Mr. Mosier.
Mr. Chairman, members of the committee, Mike Mosier, Wyoming State Liquor Association. In support of this bill, we were kind of the Switzerland in this because we have beer wholesalers that are members and we have microbrewers that are members. I salute the two individuals to my left that did a fantastic job with their people, the good bill sponsor. This was truly a collaborative effort, and as the senior member of the liquor team, I'm really proud of the hard work that went into this because there wasn't always agreement right away. And so to address a question that came up earlier, as I mentioned, we have hundreds of members, and my board has known about this for almost 2 years. And everybody's been in full support. The one individual case that came up, I didn't even know about until a week and a half ago, and I still have no idea why there was concerns. I think this is a tremendous help to small businesses, both our wholesalers and our microbreweries. It's not a dramatic change in Title 12. It's just a needed change. And also, since I'm a patriot and I love beer and I embrace freedom, Patriotic Beer Freedom Act, you just don't get better than that. So in support, and I'll take any questions.
Representative Haroldson and then Representative Yin.
Thank you, Mr. Chairman. So I got 6 amendments and I wanted to run through. Sorry, I couldn't resist you guys. You opened the door. Just to solidify though, obviously there is a change in contract that this will bring as far as potential change in contract. Do you have any concerns that like the original contract that was entered in, you're shifting a little bit? Do you have any of your members that might be concerned about that, or have you heard anything like that? I mean, I hear you guys' kumbaya moment, but I just want to make sure there isn't a 6 months down the road conversation that wasn't as kumbaya-like.
Mr. Agopian.
Mr. Chairman, Representative Haroldson, that is the give on our side. You know, we're going from something today that's in the statute, that's a penalty, where if the contract were to be broken without cause, outside of the process, the distributor would still be due the fair market value. If we took the party to court, we could also get court fees. So that's the give that we're making consciously and knowingly as we're moving forward. And the Malt Beverage Franchise Act serves as the floor from which contracts. And so this would be something that could not be contracted away. So they'll have this right going forward for everybody underneath the 25,000 barrels is our expectation.
Representative Yin.
Thank you, Mr. Chairman. Mr. Mosier, was your ask to rename the short title the Patriotic Beer Freedom Act? Because we can do that as a committee.
Mr. Chairman, Representative Yen, I probably would put veterans and puppies in there too if it were my choice, but the good bill sponsor would only push so far.
I think the Senate would easily concur with that amendment, Representative Yin. We can't let a bill pass through completely unamended. My question is, what took, so from my perspective, this actually is a pretty big change to Title 12 because like as a lawyer, I put my lawyer hat on, and if I didn't have this in statute, for example, the old statute, and I was reviewing an agreement for my client and it said that you're basically in perpetuity in this contract, I wouldn't advise my client to sign it. So my question is, what took us to the point that we're at now that it bubbled up high enough that we that we're changing the statute.
Mr. Chairman, I'm not aware of a specific scenario where a craft brewer and a distributor were unable to find resolution. And so when we looked at the reality of the situation and the changes being requested, it seemed reasonable to support a change in the statute that reflects what we're doing currently in practice.
And to follow up on that, Mr. Chairman, microbreweries haven't been around that long. We only passed that legislation. I'm trying to look at anybody old enough to remember that, Chairman Harshman. But I think we did microbrewery laws back in early 2000s, and so they really haven't been around that long, maybe late 90s. And so when they reach the point of developing where they want to distribute their product, that process hasn't been around that long. So I've heard of this issue, but it's not been, what we're doing is kind of addressing it before it becomes an issue. And it was kind of a give from the wholesalers, and that's part of what I think everybody appreciates about it, because it gives on both sides.
Okay. Other questions, committee? All right. Well, thank you for the kumbaya. Other public testimony? Is there any online public testimony? No? Are we even online? Okay, well, that's good. All right, I will close public testimony.
Move the bill.
Then moved by Representative Harshman and seconded by Representative Chadwick. Any amendments to the title of this bill? It's so tempting, isn't it?
Mr. Chairman, I think I would only do it with support of one of the co-sponsors that might be on this committee.
I'm a co-sponsor. Okay. Representative Newsom's a little hesitant as a co-sponsor.
Question on the bill?
There are no amendments to this bill. Any discussion on the bill? All right. Question being called. Will you please do a roll call vote on Senate File 79?
Representative Chadwick? Representative Haroldson? Representative Harshman? Representative Knapp?
Aye.
Representative Newsom? Representative Ottman?
Aye.
Representative Wiley?
Aye.
Representative Yin?
Aye.
Chairman Olson?
Aye.
That's 9 ayes, do pass.
All right. And Senator Barlow, I will floor manage this for you with, and I'm sure Representative Newsom will back me up. Thank you, Senator.